Okay, and Mr. Fischer, you'll go first this time around.
Thank you, sir. May it please the court, counsel. My name is Dan Fischer, and I appreciate the opportunity to appear before you here today, and I'm privileged to do so on behalf of a New Jersey company called Summit Nutritionals, Inc. Now, Summit Nutritionals was incorporated in the state of New Jersey, and its principal place of business is in the state of New Jersey. And as it turns out, those are the two dispositive facts on the appeal before you. What we've appealed is the trial court's ruling that there is general jurisdiction over Summit Nutritionals in Iowa. And we assert that that ruling was in error as a matter of law based on the evidentiary record before it. And it's important to note that the evidentiary record before the court was only provided by Summit Nutritionals and was undisputed factually.
And I really think that the U.S. Supreme Court decision in Demler overrules what the district court did on general jurisdiction.
Yes,
but
sir.
The question is, could it be affirmed on the basis of specific jurisdiction?
Certainly, and actually, Mr. Osborn and I had talked about, I don't think we cited Daimler to the court in either of our briefs, but I was going to talk about that here. I would agree with you on that. So turning to the issue of specific jurisdiction. Now, that was not an issue addressed by the trial court for Summit Nutritionals, but it has been argued alternatively by the plaintiffs on this appeal. So turning to that, there's three reasons why specific jurisdiction would not apply in this case. First of which is that specific jurisdiction is solely based on the conspiracy theory or on a conspiracy claim. And there's a split of authority right now as to whether or not that's constitutionally viable. Now, this court may not want to answer such a broad question, and you wouldn't have to, for the other two reasons that specific jurisdiction is not available in this case because they're case specific. Those two reasons are, first, the district court, the trial court, actually did rule on the conspiracy and specific jurisdiction with respect to the other foreign corporations that were brought into the suit later on, like Summit Nutritionals was, and that was the Federal Labs defendants. And it was a Federal Labs Corporation and Federal Labs Chemical Corporation. I'll refer to them just as Federal Labs. After finding there was general jurisdiction on Summit, it turned to whether or not there was specific jurisdiction with respect to Federal Labs. And what happened with Federal Labs is the trial court said, let's assume that you can base jurisdiction, specific jurisdiction, on a civil conspiracy theory. I'm going to follow the Northern District of Iowa's opinion on that. And the court found that the plaintiff failed not one, not two, but all three elements put forth by a court that recognized that civil conspiracy theory with respect to Federal Labs. Now, why is that important to the discussion of Summit here is because the plaintiff's allegations against Summit are identical to those against Federal Labs. There's no difference.
What about the sale of the allegedly adulterated product, the chondroitin that your company sells that they contend is mislabeled or is misleading the public or something like that? Wasn't there a sale made into Iowa that was prior to this lawsuit being filed, which is, again, if you extend to the patent analogy, that would be kind of par for the course. You get a stalking horse to make a purchase of the infringing product, get them to sell it, hopefully into the Eastern District of Texas, and then file that lawsuit there, knowing that establishes jurisdiction. Why doesn't that one sale by your client establish jurisdiction in Iowa?
Certainly, because of the U.S. Supreme Court's recent rulings this year on jurisdiction, both the Daimler case on general jurisdiction and the case on specific jurisdiction, which talks about that the acts of third parties, including and particularly the plaintiff in a case, the plaintiff's acts cannot create jurisdiction over the party that they want to bring here. So
the client knowingly made a sale into Iowa, right? If it was 100 sales, would that still not be enough in your view?
If the sales were all to the plaintiff for the purposes of establishing jurisdiction, then the case law is very clear that no, that does not establish jurisdiction in Iowa. The Supreme Court has been absolutely clear on this, that sales made to the plaintiff, to the person attempting to establish jurisdiction, are not considered as part of the jurisdictional analysis. Now, with respect to this, and we were talking about bases why specific jurisdiction is not appropriate, in addition to what we've been discussing on that issue, the trial court, just 3 days before it ruled on jurisdiction, ruled on the Eagle defendants, the ones you just heard from, motions for summary judgment on the very same complaint we're here talking about, or petition, excuse me. In that case, the trial court dismissed, with prejudice, on summary judgment, all conspiracy claims against all defendants. I mean, the trial court did not delineate which defendants it was talking about. It simply said the conspiracy cases are out because the plaintiff failed to provide any evidence, even sufficient to simply create a question of fact as to whether a conspiracy existed. So what do you have left over as yet another reason why specific jurisdiction is not available in this case, aside from the conspiracy theory dispute, is because there's no one left for plaintiffs to allege that Summit could have conspired with. You cannot have a conspiracy of one as a matter of law. Federal Labs is out due to jurisdiction, and all of the other defendants got out on summary judgment on that claim. So for that additional independent reason, specific jurisdiction is not available to this plaintiff because they could only allege a conspiracy of one. And be clear that conspiracy is these plaintiffs' only basis for specific jurisdiction against Summit Nutritionals.
Is there also an overt act requirement? They must prove an act taken in Iowa by Summit to further a conspiracy, and was that ever pleaded?
With respect to specific jurisdiction, there has to be some element of purposeful availment. These new U.S. Supreme Court cases are instructing us that actually the language of continuous and systematic is actually more appropriately applied and is required to be applied to a specific jurisdiction analysis, not a general jurisdiction one. And with respect to that, one of the ways that courts have analyzed this is whether or not there was any purposeful availment of protections in Iowa to Summit. And I would submit to you that the record is undisputed that there has been none in this case. There has been no overt act certainly by Summit. In fact, if you look at there's only 2 paragraphs of the petition that even reference Summit by name. Paragraph 9, which identifies Summit and alleges that it has a manufacturing facility here, which the undisputed evidence is that it does not. But secondly, paragraph 55, and this is what paragraph 55 of the petition actually says. It says that the Eagle defendants manufacture the chondroitin sulfate and ship it to Federal Labs and Summit, who then redistribute it elsewhere, including Iowa. But the problem with that allegation is, again, the factual record on the motion to dismiss on personal jurisdiction was undisputed that neither Federal Labs or Summit ever sold any products to Iowa or in Iowa. And that was undisputed by the plaintiffs on the factual record. So on the record before the court, specific jurisdiction simply is not available to these plaintiffs.
What about the argument that Summit held itself out as having an Iowa manufacturing facility on its website? Is that enough to consider it at home here under Daimler?
It is not, for a number of reasons. One, Daimler has been very clear as to what the hallmark of at home means, and that is that it's either a principal place of business or that it was incorporated there. And neither of those are the case with respect to Iowa and Summit Nutritionals. Now, you do wonder, okay, well, what about the fact that there was that representation? Well, first, we would challenge the representation itself. If I tell you I'm a distributor of yellow widgets and my manufacturing facility is in China, does that necessarily mean that I own that manufacturing facility, or am I just communicating to you where I get my widgets from as a distributor? And I think we all use certain parlance like that. I talk to my accountant. I go to my dentist. I have my plumber come fix my
But when you look at the Xerox, the screenshot of the website, it has Summit's name on it with the Sioux Center address. So it sounds like it was that Summit owned it.
It does. It does leave that impression. And what the cases that talk about what happens from websites and whether they can establish jurisdiction, the cases that talk about that are keen on whether there's any evidence that the website was relied upon by anyone in the jurisdiction. And in this case, zero evidence of that. There is nothing on the factual record that suggests anyone was ever misled by that web page, that anyone ever relied on it, or in fact that anyone ever in Iowa ever even viewed it. And so I think on that record, that webpage, while at least a point of discussion, certainly, and something that has been fixed as these issues have come up, does not rise to the level required by the U.S. Supreme Court for general jurisdiction. And it certainly doesn't establish the systematic contacts for specific jurisdiction. Thank you for your opportunity to talk to you about this today.
Mr. Fischer, thank you very much. Mr. Osborn.
Thank you, Chief Justice. May it please the court. Counsel. The facts of this case involve a defendant, Eagle, which is also an Iowa company like Sioux Pharm, who manufactures, sells, and ships chondroitin sulfate to Summit on a monthly basis, where Summit then packages it and sells it while representing it to be substantially purer than it is. And in terms of specific personal jurisdiction, which I'll talk about first, the modern approach for specific personal jurisdiction is a two-prong approach discussed in the capital promotions case. And the two prongs are, number one, did the defendant purposefully direct its activities at the forum? And number two, did litigation result from alleged injuries arising out of or related to those exact activities? A single contact with the forum can be sufficient for due process purposes. In fact, in the Norton case, this court upheld specific personal jurisdiction over a non-resident based upon a single phone call into the state of Iowa when the lawsuit alleged that that call was harassing. Because the lawsuit necessarily arose out of that single contact, this court affirmed a finding of specific personal jurisdiction. This case is not about a single batch of misbranded chondroitin sulfate. It's about an ongoing and repeated scheme to buy a product from somebody in Sioux Center, have it shipped to New Jersey, mislabel it, and sell it as something it's not. And obviously, Sioux Pharm's alleged injuries stem directly from that precise scheme.
Could you address the counter-argument that the allegations of conspiracy have been dismissed by summary judgment, some of them, and then also the federal labs got out on a jurisdictional defense?
Yes, yes, Your Honor. In terms of the summary judgment motion, I do not believe that counsel's representation is correct. I believe it's a misreading of the opinion. I do believe the district court could have been more clear in its ruling, but it's clear from the record that our case was bifurcated into the trade secret theft case and this adulteration case. The summary judgment motion didn't have anything to do with what we're talking about right now, although I could see how the opinion could have been fleshed out perhaps and been a little more clear. It is certainly my contention that the conspiracy claim as it relates to the dilution and misbranding claims is still live. And there's a big difference between federal labs and Summit because federal labs had no contacts with Iowa ever. Here we're dealing with a company, Summit, that receives shipments monthly, pays monthly. It's a totally different set of circumstances. They had actually been to the facility in Iowa to visit it. I think that they are in a dramatically different boat, so to speak, than Summit. Now, Summit, in terms of their website, this isn't a case about the internet. It doesn't matter where the representation was. Summit cannot reap the benefits of a deliberate representation on its website without reasonably expecting to be held into an Iowa court to respond to claims that relate directly to its manufacturing and distribution processes.
What benefits did they reap from that representation?
Well, the evidence before the court is that these two companies, Eagle and Sioux Pharm, are the only domestic competitors in this industry. So by putting on their website that their facilities in Sioux Center, we believe that, and interpreting all facts favorably to my client, We believe they did that intentionally so that people might be misled into actually thinking that, oh, they're the company in Sioux Center where the good chondroitin sulfate comes from.
Do you need some evidence that somebody in Iowa actually looked at the website?
I don't think you do. You know, in terms of jurisdiction and due process, it's all about fairness. And when you have a company that says it's at home in Iowa, to use the parlance of our times from the Goodyear case and the Daimler case, it's certainly fair to hold, and I know we're switching over to general personal jurisdiction a little bit, but it's certainly fair to hold somebody accountable and find them at home in a place where they tell the world they're at home. They could have done this on billboards. They could have sent flyers to every single person in the country, or had advertisements on the back of buses telling everybody we're in Iowa. And fairness dictates that they should reasonably expect to be sued here.
Mr. Osborn, if I could interrupt, because I think, are you, this one sale that was made into Iowa by Summit Health to some straw man that your client had an arrangement with, are you claiming that that product is some of the adulterated product that's covered by your Lanham Act claim?
Absolutely, yes.
And there's no question that Summit intentionally sold that made that sale, knowing that it was going to go to, it was shipping the product to Iowa?
That's my best recollection based on the record. Yeah.
Did you rely in district court on an argument that that sale was a basis for personal jurisdiction over Summit?
On that particular sale specifically referenced, no.
Is that your contention here?
No, I think it's one piece of the puzzle, but certainly not what we relied upon heavily.
Is it accurate that your client didn't rely on the website representation about Summit having a manufacturing facility of its own in Iowa?
I will say that probably more appropriately and accurately, there's no record that my client relied upon it. Now, I do want to talk for a moment about general personal jurisdiction.
Let me just follow up on that. Does that mean that becomes a legal question, whether if someone boasts of a false claim on a website regarding sufficiency of contact with the state, that that in itself can or cannot become a factor in determining jurisdiction?
I think it's a mixed question in some respects, Chief Justice, because I think you got to evaluate the facts and circumstances of each case. So I don't know if it's clearly just a legal question. And in terms of the standard for general personal jurisdiction, courts have repeatedly rejected arguments such as the argument that Summit's making here today that, well, we said we had a facility there, but we really don't. We cited the Turpin case from a Massachusetts federal court where the defendant had put some brochures out saying they had an office in Boston, and the court basically said, you know, tough luck. You represented yourself as being there. You can argue it away, but you can't change the facts that you made that representation.
They did say that, and they clearly relied in part on that, but that case also involved the defendant's sale of a product that then injured a Massachusetts worker in that state, and so we have a traditional product liability. You have a separate argument for jurisdiction apart from the brochure, don't you?
I agree it is distinguishable, but it's similar from the standpoint that there was a representation that was made that served as a basis for personal jurisdiction. The defendant then tried to retreat from it, and the court said, you can't retreat from it. And
should we use the Zippo test for looking at when a website can be used as a basis for jurisdiction?
I really don't think that this case is about the internet. It's more about waiver and estoppel to me. When you make representations, personal jurisdiction can be waived. You can be stopped from denying it. You can't make representations for some reason because it's apparently convenient for you. I think it's presumed that you make a representation for a reason. It's deliberate. And then try to unravel that when it becomes inconvenient for you. And like I mentioned earlier, I really don't see this as an internet case. I see it as a case of waiver estoppel based on representations made, regardless of how or where they were made.
So on estoppel, one of the elements the party asserting estoppel needs to prove is that they relied. And again, does estoppel fit here for you if there's no reliance by your client in the record on the website statement?
There certainly is no evidence of reliance by my client in the record, which is really why the focus is on waiver, and based on their deliberate actions, they waived the arguments that they're making here today. Thank you.
Thank you as well, Mr. Osborn. Mr. Fischer, you may present your rebuttal.
Thank you, sir. May it please the court again. We heard the plaintiff say at least 3 times to you that there were monthly shipments. And one of the things I would turn this court back to is your case in 1970, which actually cited to a 1962 Minnesota case, where you distinguished between foreign buyers are different from foreign sellers. People who sell into Iowa may be subject to jurisdiction, but people who simply contract with Iowa residents and buy out of Iowa, you would not subject to the greater reach of jurisdiction, because that could put anybody, and it could still, or chill, commerce. So this court has already addressed that. We've briefed those cases, but that was your 1970 case that talked about that. I believe it was Rath. Also, we heard plaintiffs talk about the repeated scheme that they are trying to get at here, but let's keep in mind what even the trial court, on the record that the plaintiffs put before it, said about that repeated scheme. Specifically, I want to turn you to the record at pages 115 and 116, which is the summary judgment ruling by the court. And this is, the appendix, pages 115 and 116. It's actually pages 14 and 15 of that corresponding order. And the trial court actually said that the plaintiffs rely on an allegation that the Eagle defendants were receiving information to support some inference of an agreement. And it goes on to say that there was no genuine issue of fact regarding the existence of a civil conspiracy by the defendants. So the scheme that they allege is there, they didn't have enough evidence on the record before the court to even create a question of fact of. I would also turn you to the appendix, pages 124 to 125, which is the trial court's ruling on jurisdiction, specific jurisdiction with respect to federal labs, and that same scheme that the plaintiffs were up here talking about. And it says that that Sioux Pharm has failed to present even a prima facie case. And it says that all of its allegations are ambiguous and based on unreasonable inferences and speculation. So even what they presented to the court was not quite this clear scheme that they believe occurred. Also, there was a question to the plaintiffs about the Zippo test, and I heard as part of the response by the plaintiffs that the internet isn't part of this case. This isn't an internet case, and that's somewhat extraordinary statement to me, because the only reason why we're here talking to you fine gentlemen is because the trial court said, solely on the basis of a page off of our website, that there's jurisdiction over us.
There are internet cases, and then there are internet cases. I mean, the Zippo factors deal with putting apart the content of what is represented on the website page. Is the mere fact that your website is accessible in the jurisdiction and can be used as a basis can be picked up by people in that jurisdiction, is that a sufficient basis for jurisdiction? Here they're relying on the content of the website, on a representation of a connection to Iowa, and that seems to me that isn't addressed in Zippo, is it?
Well, I believe it is, Your Honor, respectfully, because Zippo addresses the continuum of cases that involve websites. And they say that websites can go from one spectrum where they're simply informative and there's not a lot of interactivity to it, to the other spectrum where there's a lot of interactivity, where you can order things, you can reach out and contact them and have them reach you, and that's a sliding scale depending on that. Now, the interactivity is only one factor, then you have to go to quantity after that, but right now we're talking about interactivity. All that web page was on that far left side of the scale of Zippo was informative. Now, unfortunately, it also led with maybe a mistaken impression as to we had a facility in there. But if you're going to step outside of the Zippo cases, what do we have left to look at? Well, what we have left to look at is the general and specific jurisdiction tests we've been talking about. Daimler says clearly that that statement, even if wrong, isn't sufficient to be at home. And on a specific jurisdiction, we have the problem of the lack of anything in the evidentiary record that it was relied upon. So there's nothing on that statement, nothing in that website, whether you're going to evaluate it as an internet case or not.
Can that statement be regarded as a waiver of your objection to personal jurisdiction when you claim inaccurately, apparently, but you still, the statement is made that you have an Iowa manufacturing facility? Why isn't that a waiver of objection to personal jurisdiction?
On this record, certainly it could not. And I say on this record because remember, waiver is a knowing and voluntary, it's a voluntary relinquishment of a known right. And the record here, the only record, the undisputed record, is that Mr. DePasso's or Dr. DePasso's affidavit says, look, all I was trying to do with that page was tell people this is, as a distributor, this is where I get my chondroitin sulfate. That's it. That's not enough to lead to the express finding you need to make to say that there's a waiver, a voluntary waiver of a known right simply off of that statement. The last point that I would make is that I think I heard the plaintiffs say something about you don't need, this case isn't about the evidence, it's about fairness, but I would respectfully disagree. Oh, I think I'm out of time.
Please conclude.
Thank you, sir. I would respectfully disagree for simply the person, the plaintiff is the one that carries the initial burden of proving jurisdiction. Now, under Daimler, they can't do that on general. And under specific, on the same allegations made against us, they've already failed that with respect to the other defendants that were let out. And with that, I thank you for your time and the opportunity to appear before you today on these issues.
Thank you as well, Mr. Fischer. The case then is submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.